Hello, everybody. Welcome to Crypto Coin Mindset. I'm Keith, and as always, I'm here to help you get your mindset on crypto. You're about to watch one of the guest speakers from the Free State Bitcoin Digital Asset Conference, which was held in New Hampshire on September 1st, 2024. Now, I just want to preface this video by saying I went ill-prepared to this conference. First time I had ever been to this conference, but I went ill-prepared. I should have had a separate Wi-Fi connection. So the video itself is not too great, but the audio works fine. So I hope you enjoy this video from one of the guest speakers at the Free State Bitcoin Digital Asset Conference.
So winter, what we're going to be doing is going through, I had a slide presentation, so unfortunately we don't have a slide, well maybe fortunately because it's outside, we don't have a projector, so I'm just going to go and talk about the things we talked about then, kind of track how those issues change, and then what we'll do is have some projections for the future. So unfortunately you won't get to see my hilarious slide deck that I prepared last night for 3 hours. So for example, this disclaimer, which is on the Doge meme theme, it says such words as such disclaimer. I am not your lawyer until an engagement letter is signed and the retainer clears. This presentation is not a substitute for legal advice. Wow. Okay. So just by way of background in terms of what my experience is, I've been practicing law since about 2009. I'm a dual qualified lawyer in England and Wales, New York, DC, and the state of Connecticut. I've been doing crypto since 2013 and full-time since 2014, where we started in London, we forked Ethereum Proof of Concept 3 and went around to a bunch of banks and said, hey, you should build this. We made absolutely no money. We should have just taken our venture around and put it in ETH tokens and I'd be on an island in Tahiti instead, but we didn't do that. And so as a result, now I'm still practicing law and slating away. But I have a small law practice. I have clients all across the crypto space in the US, UK, UAE. And what I do is basically provide strategic advice to companies that are doing crypto-y things or things in the free speech and social media arenas. So for this talk, we're going to try to just kind of not rush through it, but we're going to move through it pretty quickly because I tend to find that people have a lot of questions and I want to save some time for Q&A so that can address your specific issues. So what we're going to talk about today is the bleak for the last year, and it has been bleak. Amen. And then sort of we're going to talk about some so the changes, right, that we've seen, some partial victories that the crypto industry has had in the courts, and then we're going to talk about what comes next in 2025. So there's a slide in front of me that I'm looking at from Liberty Forum 23, and there were 3 bullet points, right? One was a bleak U.S. regulatory environment. We said that'll likely last until a change of presidential administrations, and we probably won't get any new legislation. That's broadly true, still true. Crypto winter will likely last another year. That was roughly true, depending on how you measure crypto winter. So, the growth at the major retail outlets, particularly in the United States, has slowed. We have seen growth elsewhere. We'll talk about that in a second. And the next wave of growth will likely come from outside the United States. So those are the 3 points we brought up at Liberty Forum a year and a half ago. And the question is, was I right? And it's a little bit of a mixed bag, but I was mostly right because I'm brilliant. So on the bleak regulatory environment, I'm kidding. I'm retarded. The bleak U.S. regulatory environment, Binance was sued on June 5th of 2023 for operating a unlicensed securities exchange by the SEC. We'll talk about that a little bit more in a second. Coinbase was sued the next day, June 6th. Yes. Kraken was sued on the same grounds on November 21st, 2023. And Binance pled guilty to a number of financial crimes in November of 2023. And since then, a number of states, including Alaska, Maine, North Carolina, Oregon, and others, have revoked Binance's state money transmitter licenses. So Binance can no longer do business in those states. So in terms of the bleak U.S. regulatory environment, shortly after we had this last check-in with the Free State Project on crypto issues, the SEC waged all-out war on the crypto industry and went after the major market operators. In terms of crypto winter, it did basically still kind of lasting. The markets are sort of flat. There was a small boom following ETF approvals in early 2024. That wouldn't have happened but for the fact that Barry Silbert, it's a controversial figure, but Grayscale sued the SEC in the District of Columbia and said, listen, this is outrageous what you're doing, denying these ETF approvals. It's not your job to deny these things. if they meet all the facial requirements that an ETF does. And so the SEC lost the lawsuit and started approving Bitcoin ETFs and Ethereum ETFs. So they're still growing, right? It's an exponential process. It's a long game, but crypto winter, I think, is still, it's maybe it's thawing, but not quite. And in terms of the next wave of growth, where it's come from, the regulatory consequences of the American government, or the American government's enforcement actions meant that the growth was first, this is from Chainalysis, the highest growth jurisdiction was India, next was Nigeria, next was Vietnam, and then after that was the United States in fourth place. So despite the fact that our GDP in this country is considerably larger than in those places. So I think it's fair to say that the US regulatory and legal picture has had an impact on the growth of crypto, which also means that a change in the regulatory picture will change, right, how crypto evolves. And so that should be a relevant consideration, right, as you're considering how to position yourself in relation to the markets. So what are the big bads, right? What are the big problems with the crypto industry in the United States? We can talk about all kinds of issues, legal issues of crypto. What are the four really big problems that need to be fixed? There are four of them. I call them the four horsemen. The first one is the Securities Act of 1933, which applies principally to coin issuers. The second is the Securities Exchange Act of 1934, because of the status of coins as securities under the Securities Act of 1933, or the alleged status of coins as securities under the Securities Act of 1933. That has had consequences for venues that trade them. We'll talk about that in a second. The third one is the Commodities Exchange Act, which I'm not an expert on, and we talk about very briefly. But basically, there are a lot of crypto derivatives projects and trading projects out there, and there are certain requirements for registration, which is essentially impossible for a DeFi protocol to comply with. And so as a consequence, that entire universe is off limits to US investors and foreign companies wanting to service US investors. And the fourth one is tax, right? Which, in relation to which there's no de minimis exception for crypto as a currency transaction, right? So if you dispose of Bitcoin or any other cryptocurrency, you got to do a capital gains calculation or an income tax calculation, or income tax rates capital gains calculation if you've acquired and disposed of it within a year, right? So we're not going to really talk about tax because that's a pretty simple one. We're going to really laser focus on the securities issues and talk briefly about the commodities issues before going to Q&A. So the Securities Act of 1933 is a law which governs how people can sell securities out in the market. The key case, right? Who here has heard of the Howey test? Show of hands. Right, just about everything, right? So does anyone know the story about Howey? What it came from? Orange groves. Orange groves, exactly. You want to talk about it a little bit, or you want me to talk about it? Pass. Okay. So Howey concerned orange groves. The SEC enacted the Securities Act of 1933 in the wake of the Depression because the government stupidly thought that regulating the economy would make it better. Of course, it didn't. World War II made it better. So what happened was, and it was, anyway, long story, everybody. I know that I'm in a room of fellow travelers, so I don't have to get the details. But the Securities Act of 1933 said that if you sell things like securities and other stuff out in the public markets, you have to comply with certain registration and disclosure requirements. So if you sell shares, stocks, bonds, debentures, all kinds of instruments. But there's a term in the Securities Act of 1933, Section 5, which refers to investment contracts, right? And investment contracts is not, or at least at the time, wasn't a term of art, right? It was a blanket term designed to cover things that weren't expressly covered. If something's a stock, you know it's a stock. If something's a bond, you know it's a bond. It states it on its face. It has a legal definition that's objectively provable. But investment contract, what is that? And we found out what that was in 1946, in this case, Howey. Customers were offered two contracts in relation to orange groves, right? They would sell land to an orange grove, and then they would sell a service contract in relation to that orange grove. And the consequence of the sale of those two contracts is that the investor would receive money, but not do any work, right? And so they said, well, this isn't an investment contract. This isn't a stock. This isn't a bond. The customer owns the land, right? It's their land. And we have a service contract. We're just servicing the land that they own. And the court looked at that and said, well, actually, this is really an investment play in the other day, right? It just is the same as anything else. Basically, so they got the service contract, gave Howey possession of the acreage, full discretion over land management. The landowner had no right of entry, right? Which is kind of inherent to owning some land, and no right to specific fruit. And the produce then was all pooled, and then the revenue was paid proportional to the results in the field. So they said, listen, you're actually investing not in the plot of land, you're investing in the entire enterprise, much like you would if you were a share or something else. And so we came up with the Howey test for that. And the Howey test says broadly that if there's a contract transaction or scheme involving the investment of money in a common enterprise, with the profits expected to arise from efforts of others, a promoter or a third party, that arrangement is going to be considered an investment contract and therefore a security and therefore registered as a security under the Securities Act. Now, crypto comes along, right? So does an airplane, but crypto comes along. And initially, nobody knows what the hell this thing is, right? Because when you buy Bitcoin, are you buying into a common enterprise? Is there an issuer? Who's the CEO of it, right? Who knows the CEO of it? Craig Wright, obviously. So obviously, you don't know, right, what it is. But then, shortly after Bitcoin started seeing businesses selling their own crypto tokens. And in some cases, those businesses would bundle together promises with those crypto tokens. Now, is that a security? The SEC argues that it is. Issuers will argue that it's not, and that crypto performs functions and does things that traditional stocks don't do. I understand we had a very short presentation this morning about helium. So helium is one example of a system which is conceivably regulatable as a security, right? However, it does things that securities don't do. It provides some kind of system where you can communicate via wide area networks, and that provision is being done on a decentralized basis by decentralized infrastructure. So even though there are certain aspects of crypto tokens which do look like investment contracts, and in particular the economic understandings when a company sells them to people, right, in advance as part of an initial coin offering or something like that, there are also aspects of it which are nothing like crypto, nothing like securities, right? Absolutely nothing to do with it. They perform functions that no stock, nor to bond, nor to venture, nor any other instrument has ever historically done. So that suggests that maybe we need to update our laws to accommodate a new regime to do this. And Jonathan Mohan is going to talk about what those are later today. So I'm not going to steal his thunder. So that's the Securities Act of 1933. Securities Act of 1934, Exchange Act of 1934 is the next problem, right? Because it says that, I wrote some wonderful pseudocode here, so maybe I'll read that. If all cryptocurrencies are investment contracts and all investment contracts are securities, right? And, right, you're running a securities exchange, you're running an exchange of those. If exchange facilitates cryptocurrencies, then exchange is an exchange of securities, right? So if the SEC cannot register, right? So there's an obligation under Section 5 of the Exchange Act, which says that if you're trading securities on an exchange, you have to register as a national securities exchange. Okay, so you've got to do that. You can do stocks, bonds, debentures. But if crypto is also a security, right? Well, if you're trading crypto, you also have to register as an exchange. What's the problem? The SEC doesn't have a registration pathway for cryptocurrency coins. You can go to the SEC, you can hand them an S1, you can say, I've got my cryptocurrency here. Please publish this S1 and let me list it somewhere. And firstly, there's no exchange that can do it. Maybe INX can do it. That's another discussion. But if all crypto is regulated as a security and the SEC won't register it, right, then no exchange can list it, right? So it's impossible for the exchanges to actually list the tokens because the SEC will not confer registration status on tokens because crypto tokens don't fit in the current regime. So the end result of that is that much of crypto business, which is lawful in the rest of the world, is not lawful here because the SEC won't give us rules and Congress hasn't given us legislation, which will say, okay, we recognize there's not a neat fit between these two things. And we also recognize that Americans want to buy it. So here's an appropriate registration and disclosure regime. Now there's a proposal for that called FIT 21. Jonathan will talk about it later today. That might fix this, which would be great. But essentially, Securities Act says most cryptocurrencies gives the discretion for the SEC to say most cryptocurrencies are securities. Exchange Act says you can't trade securities unless you're a registered securities exchange, and you can't trade unregistered securities. And if you can't register the coins, then you can't list them on the exchange. And that's why Binance and Coinbase Company are up in the suit. So the developments in terms of where securities enforcement has gone in the last couple of years. In 2017, there was practically no enforcement. I'm happy about that. So in 2017, I was actually at PortFest. What's that? No, it was a month after PortFest. The SEC published a report called the Dow Report, which was the first official regulatory guidance, which said, selling these tokens might constitute a sale of security. Be aware. And then nothing happened. for another year. So ICOs have been going on since 2013. The first time the US government had anything to say about it was 2017, right? And then no enforcement actions were published after that. November 2018, right? So a year and a half later, you get the two first ICO enforcement actions against a project called Paragon and another project called Fairfox. Not the best project. You also had other enforcement actions against Floyd Mayweather, Khalid for touting securities, and Ether Delta, which is a decentralized exchange that apparently ran under some guy's bed on the server. Anyway, and Ether Delta settled with the SEC for running an unregistered exchange. Right, this is 2018. So then 2019, you start to get the first really big cases. The SEC set some precedents with some little cases, not legally binding precedents, but rather administrative precedents. And then projects. Kick Interactive got its butt kicked.
Yes.
Unintended. In 2019 by the SEC, $100 million ICO. SEC found it was selling investment contract. They lost. 2020, Telegram. Everybody knows what Telegram is, I assume. Telegram did their own cryptocurrency called Ton. There's now a subsequent, the open network cryptocurrency, which is different. But Telegram did a $1.7 billion ICO where it sold a bunch of tokens to institutional investors in the United States. About a week and a half before those tokens were due to be released to the investors, the SEC filed an emergency lawsuit in the Southern District of New York. Saying, we got to put a stop to this because they're about to flood the market with all of these tokens. They put a halt to the sale. Telegram somehow spent half a billion dollars, and so they returned 1.2 billion to their investors after raising 1.7. I've seen the documents. They were allowed to do it. It's a really bad deal for the investors. And then, of course, 2022, we had Library Inc.
Yes.
The ruling Library Inc. Everybody knows Jeremy here. Everybody knows who he is. So that was a case where you had an actual platform, right, that was actually doing useful work where cryptocurrency served a useful consumptive function. And the SEC went after him and said, listen, this is securities offering too. So the picture the SEC was painting, right, up to 2022, they were winning everything, right? Winning every fight, winning every ruling, winning every judgment. That changed this kind of in the last 12 months. So the first partial defeat the SEC had was with Ripple Labs in 2023. So Ripple Labs, the Ripple token, everyone knows what Ripple is, show of hands. Yeah, so Ripple's a cryptocurrency. Started in 2012, and in 2023, they won a partial summary judgment ruling from Judge Torres, again in the Southern District of New York, where Judge Torres basically said that principal initial sales of XRP tokens to institutions, those were unregistered securities offerings. However, secondary sales of those tokens on exchanges where the user or this purchaser didn't know who they were buying them from were not securities transactions. That was the first chink in the armor of the SEC. The second one was SEC versus Finance Holdings, the ruling of Judge Berman Jackson, Amy Berman Jackson from the District of Columbia. And there, Finance had been sued on 12 or 13 different counts relating to selling securities, operating an unregistered securities exchange, et cetera, et cetera. And the count regarding the secondary sales of BNB, which was their in-house stablecoin, was dismissed. They won dismissal on the secondary sales of a dollar-based stablecoin, the dollar-based exchange token. And they also had a count dismissed on the sales of their BUSD stablecoin. Right now, interestingly, Paxos, I believe, partnered with Finance in relation to the BUSD stablecoin, and they were under investigation in the United States by the SEC. And a couple months ago, or last month, the investigation was dropped by the SEC. So they're starting to lose on the very periphery of their power, where it's not really a strong argument to say this thing is a security inherently in itself, right? They're sticking to, and they're winning when there's a direct transaction where you can prove there was an investment contract in the share. So similarly, SEC versus Hero Systems. Hero Systems, run by a friend of mine, Alex Miller. They run the Stacks blockchain, which is a L2 on Bitcoin. They had their investigation dropped. The SEC was investigating them. They did a Regulation A crowdfunding raise, and they had tokens which were being traded on these exchanges. The SEC investigated, and the SEC said, you know what, it's not worth it for us. We don't think we can do that. And finally, there's Kraken. The SEC has also sued Kraken on much the same lines that it has Binance and Coinbase. This case was before Judge Orrick in the Northern District of California. Kraken just lost across the board on its motion to dismiss, so it was not as successful as Binance. or with the labs. So, and we'll TBD what happens with Coinbase. So, also last week, the SEC sued OpenSea. Here's what OpenSea is, show of hands. Yes, OpenSea is an art marketplace to sell NFTs. On this one, they sued them. Well, they're not sued. They haven't sued them. They've announced that they're going to sue them by providing a notice. It's sort of a last chance for the other side to come in and say, you know what, we surrender. That's fine. We're going to give up. We know you're going to sue us. We know what your arguments are. It'll be interesting to see what happens with this because unlike the securities exchanges, like Coinbase and Binance, OpenSea is a user-generated content platform. And who's heard of Section 230? Anybody? Yeah, so there's a rule under US law called Section 230, which codifies First Amendment jurisprudence, which basically says that a publisher can't be held liable for the speech of someone who's using their platform or their printing press if they don't have advanced knowledge of the state before it's made. So and it's worded in the statute a little different. It says that no provider or user of an information of an interactive computer service will be treated as the publisher or speaker of any information provided by another information content provider. In this case, right, your user of OpenSea posting a picture of the dumb cat or ape NFT they post up, that's an information content provider. Federal law confers civil immunity on OpenSea for that posting, and anything that happens subsequent to the posting, right, and the contracts that the company is using to post bona fide artwork, those will be the same as the contracts that companies, or smart contracts, that companies are using to post other types of NFTs, which are security links. So I think the SEC is actually going to get its butt handed to it on that one, but no need to go into that in too much detail. And then there's the CFTC, right? So the CFTC governs derivatives. That's any contract with leverage in it, any contract with future delivery outside of 30 days, commodity futures, commodity options, swaps, leverage transactions. In order to do that in the United States, you need to be registered either it needs to be traded on a designated contract market or a swap execution facility. Most of what we see with derivatives is happening in DeFi, right, and not on centralized platforms, like, for example, a BitMEX. We got in trouble with this. So the registration requirements don't really work terribly well from how the industry is actually structured. And as a consequence, I think that it's not a good fit, and we probably need to do something in that area to accommodate that. People are going to be doing peer-to-peer derivatives transactions, and people are going to want to provide front ends that mean that you don't have to just talk to the blockchain, but in the command line, right? You can do this all in the command line by running the full node yourself.
Yes.
Anyone here run an Ethereum full node? Really? Yeah. Ethereum full, like an archive node? 11.0?
No, before the first crash. It would fit on a hard drive.
When it would fit on a hard drive, right? But not now.
And then it didn't.
Yeah, then it didn't. Right. So, nobody runs it. That is a universal fact of life. That there are only 3 people that run an Ethereum archive node. One of them is Amazon, and one of them is Joe Lewis. So anyway, that's a joke. Anyway, so long story short, it's not really possible for those types of platforms to comply. And so the policy question for us should be, I look at that and say, okay, if you talk to Gary Gensler or Elizabeth Warren, they'll turn around and go, oh, it's all illicit. It's all terrible. We shouldn't allow it. Everyone who facilitates the stuff should go to jail. I look at it and go, well, the whole world's doing it. Why don't we just come up with a regime that makes sense and provides that level of investor protection, maybe some counterterrorism, AML stuff? I don't know. Like, let's figure out something that works. But currently, the government isn't finding to do that. So the question is, and what are the predictions for 2025? I have the 2-path meme where you've got the little kid and then one path is the castle with the sunshine around it, and the other one is the one surrounded by dark clouds and lightning bolts. To choose which path you're walking down. Well, the Sunshine Castle on this meme I produced for you last night, I spent hours. The Sunshine Castle has the word Trump over, and the Thunder and Lightning Castle has the word Harris over. If Trump wins, right, I think we get market structure regulation within 6 months. Basically, it's likely going to take the form of FIT 21, which is what John is going to talk about today. And if Harris wins, you're probably going to have multiple renewed efforts of censorship across multiple domains, including crypto, including social media, right? With social media, we see that basically the US government and the State Department, which likes censoring the internet, but can't do it here because they're limited by the First Amendment, they're using foreign proxies to turn around and censor Americans who are providing facilities and utilities for people to express themselves. The US government and its foreign policy apparatus doesn't like, right? Brazil, the other day, They said to Elon Musk, we're going to close you down in Brazil. We're going to kick you out of the app store. We're going to fine anyone who uses your app $8,000 a day if they do so. And in addition to that, we're going to freeze Starlink's accounts. Right? Starlink, Elon, and X are not the same. Right? Under any legal system worth the name, you cannot be held liable for someone else's torts that you had nothing to do with. And that's what Brazil's doing. So I expect that if Harris wins, we're going to see more of that unofficial stuff. Operation Choke Point 2.0 will continue here in the United States. And it's going to be ugly. So yeah, whatever, if you have any hang-ups about voting for Trump, don't. And that's my presentation. Happy for any questions.
Oh, Brett, you mentioned that 21, was it 21 like Bitcoin improvement proposal?
Bit 21, financial innovation, Bitcoin 21st Century Act.
Okay. And then, second question, you mentioned Coinbase was TBD.
Coinbase is TBD. They've been sued by the SEC. We haven't seen where the preliminary motion practice is leading to, whether they're going to win a motion to dismiss or something like that. We did see what happened with Binance, because Binance is moving on a different schedule. And so Binance won dismissal of 2 of the counts against it, which is good for the industry. Whether it holds up is another question. We also have, for example, Terra Luna, right? Also in the Southern District of New York for Judge Rakoff, where none of those are discovered, right? So currently, whether secondary sales of tokens constitute securities transactions is very much a
What would be the consequence of Coinbase kind of if it goes the wrong way?
Coinbase is going to appeal this. There will be no immediate consequence.
Should everyone who runs a VPN run it through Brazil?
I mean, I don't think Brazil is going to be getting access to Cloudflare's logs anytime soon, so I don't think running it through Brazil is particularly helpful. But should anybody in the United States who's not obliged to comply with the Brazilian order and in a position to refuse those orders, if it's going to result in the arrest of a Brazilian for exercising free speech rights, that's a question that you'll have to determine for yourself.
So I know it's hard to look into the minds of our opponents and understand their motivation. I'm sure there are many, but I am trying to understand what the grand strategy is for the clampdown on crypto from the SEC. Is it trying to maintain the dollar as its status? Is it trying to suppress this until they can make way for a CBDC? Like what are they trying to work towards other than just being obstructionist for just stopping something they don't control?
I think they're obstructionists for stopping things they don't control because they see that something they don't control could have consequences which affect their ability to control. Yeah. So that's it. Simple as that. Got a follow up here.
I'll talk loud.
Yeah, hold on. Yeah, go for it.
So I'm relatively new to Bitcoin, and I'm not sure you're the presenter to ask this of, but I learned the term fiat currency and Bitcoin.
Yep.
Where does stablecoin fit in the crypto world?
So the question is, where does the stablecoin fit? Is it fiat or cryptocurrency? The answer is stablecoin is digital fiat. So what someone has done is they've taken an amount of money, dollars, they put it in the bank account. Hopefully they've done it solvency remote fashion. And they've given you a coupon, which someone else will accept based on their ability to redeem the dollar in that location at a future date. Is that the safest way to move dollars around? Not necessarily. Sometimes, they're uninsured. Sometimes someone goes bankrupt. Sometimes the bank, which the deposits are held, go bankrupt, as occurred with the Silicon Valley Bank in Global. So there is risk, right, in doing that, and you're exposed to your counterparty risk, but you're not exposed to either if you hold the dollars under an interest, if you hold the dollars in a vault, if you hold the dollars in a bank under 250 grand, I think you can assume that the federal government's probably going to show up. But that's Bitcoin. Your risk is basically whether you can get your private keys exfiltrated. Those kinds of counterparty. So that's
Really follow up the other stuff and kind of framing it that there is a war, it's a winter war, and you described the FTC as the big bad. The real big bad is actually the Fed and the banking interests in this arena. So I'm going to say the Federal Reserve Act of 1913 should be at the top of your list, and specifically looking at what they did with Custodia master accounts.
Still doing.
They are trying desperately in a bid for power and money to just have this completely go away by regulating it.
I think that that's persecution of custodians about the stupidest thing ever.
Right.
Because it means that you would have a regulated institution which can be subject to bank examinations, doing banking business and just holding crypto as a deposit liability, 1-for-1, and taking fees. There's no reason. Exactly. But this is what this is our country. Thank you. You see Bell over. He's so shocked.
The other party's still standing.
That's you'll go down eventually. But no, so yeah. So basically, I don't think that from a regulatory perspective, for everyday crypto businesses, the Fed doesn't usually. What the Fed does do, right, is or federal bank examiners do, is they apply pressure on banks to de-risk. So a lot of crypto businesses have trouble getting banking because of federal bank regulation, federal bank examiners. So that's problematic. I think that they're doing it. They're kind of doing it from a good place because they don't want banks to fail, and they're not certain how you can set up a resilient banking infrastructure that holds crypto and isn't going to expose people to volatility. The SEC had a ridiculous one where they basically said that crypto was going to be treated as an on-balance sheet liability rather than a deposit liability. For those of you, if it's a balance sheet liability, means you have to hold cash in relation to the amount of stuff that you hold. And crypto is zero rated, which means that you have to hold 100% of the value of the crypto you hold in cash. Even though most banks don't hold crypto, or most custodians don't hold crypto as a balance sheet liability, it's deposit liability, which means that you just like a safe deposit box. You put your aunt's, jewelry or your uncle's gold watch in a deposit box. The bank's liability is to return that watch in the deposit box. So there's a lot of stuff on the banking side that could be fixed. I'm not going to say the Fed is a big bad. I just think they're being cautious, to be blunt, and they're not. The bank regulators are not known for being invasive.
Yeah. Question on, do you have any comments on tax on unrealized gains? And second part is what happens if I lost all my Bitcoin in the voting accident?
So tax on unrealized gains is asinine to destroy the economy, and it's also unconstitutional. They need a constitutional amendment to do it. I'm not so sure that they couldn't get it this day and age, depending on what the mood of the law is on any given day. But that would be bad if that happened. But I don't see a realistic prospect that it's going to happen. I think it's designed to sort of corral the left wing of the party, of the Democrat Party, which is currently obsessed with issues like Palestine and everyone else. They're like, let's give them some really diehard communism that they can hold on to. They really like that. So I think that's the purpose. I don't think it's a serious proposal. What was the second part?
Voting accident.
Voting accident? Talk to your tax advisor. Definitely. So.
Yeah. So this is my first experience in even hearing about cryptocurrency. My first experience in cryptocurrency at all. So what are the legal ramifications of changing a source of accepting currency in my office to cryptocurrency? And are there any legal obligations that I'm going to have with my corporations?
Yeah, so it depends on the size of the transactions. If you're accepting cryptocurrency, generally speaking, over $10,000 is treated as a cash transaction. So there's a filing that you have to do with the IRS. So you want to make sure that you talk to your accountant so that, for example, let's say you have a $100,000 contract, someone wants to pay it $5,000 increments in Bitcoin. There's a risk that that can be considered structuring over its length of time. So talk to your lawyer, talk to your accountant to make sure that your IRS obligations in that respect are covered. In terms of accepting the cash in your business on a balance sheet basis, you're receiving property. If you assume you do cash-based accounting, yeah, so you do rather than invoice-based. So cash-based accounting, if the tax falls due in the period during which the cash is received at the fair market value, if it's Bitcoin, that would generally speaking be the market value of Bitcoin, which means that you may have to liquidate it. And if there's any fluctuation between the time you accept the coins and the time you dispose of it, you would have to account for the gain and loss between the date on which you accepted it and the date on which you disposed of it. So it's very complicated from a tax perspective. There are some KYC or money laundering concerns which would merit an elevated sort of posture from the perspective of compliance. So if you get someone walking in saying, hey, it's like, if someone walked into my law office and said, I'd like to buy your services and I'd like to pay your retainer in blood diamonds, right? You kind of, will you accept that? as I probably wouldn't take the client. That has happened before. Someone said, "Can I pay your retainer in diamonds?" The answer was no. Go away. I really don't want to know about this. So that's the kind of, and, and when that happens in the UK, obviously, or for UK business, there's a mandatory reporting obligation where you have to report to the firm's money laundering reporting officer. They make a report to the serious fraud office, et cetera, et cetera. So generally speaking, it depends on what your business is. If someone's buying a bookmark and they're spending $5 on Bitcoin and you're not getting lots and lots and lots of repeat transactions, right? Then that's one thing. If you're selling gold or silver or something like that, and someone buys a huge number of coins from you for Bitcoin, you're going to have an issue around the Bank Secrecy Act. You're going to have to file a suspicious activity report. So it really depends on your specific business. So it's slightly elevated risk, manageable though.
So for an average transaction of, let's say, $40, not really going to have any problems.
Depends on what the transaction is and the circumstances of business. We can get into that.
Okay. Thank you.
Any others? Going once? Going twice? Thank you very much.
All right. I hope you enjoyed that video. And if you want to see all the videos from the Digital Asset Conference, check out this playlist right here. In this playlist, I'll have all the videos from all the speakers from the Free State Bitcoin Digital Asset Conference in New Hampshire. So click on this playlist and I will see you there.